and I salute you all. Greetings to you all, the people that are listening to me. Thank you for listening to me. So basically today, our major topic of emphasis is on the bars to divorce. Bars to divorce in the layman's understanding is like the things that prohibit court from granting what? A divorce. Those are the bars to what? To divorce. And it is provided under, actually when it is categorized into two. We have absolute bars and discretionary what? And discretionary bars. We are going to start with absolute bars. And when we realize that under absolute bars, we have what they call collusion. You get collusion, condonation, and connivance. Those are under absolute what? Absolute bars. And under absolute bars, they are in line with Section 6 of the Divorce Act. Basically, under Section 6 of the Divorce Act, realize that it gives mandate that the court is required to satisfy itself so far as it is what? Reasonably, whereby the allegations or the petitioner that wants a divorce or that has petitioned for the divorce cannot give a divorce in line with connivance, condonation, and collusion. You get? That is when you read Section 6 of the Divorce Act verbatively. You'll get the gist of what they mean by what? Absolute bars to divorce. Then we start with category 1, which is collusion. Collusion, basically, this is where the petitioner that is seeking for divorce sets up his or her own evidence with the intent of what? Divorce. You set up your own evidence with the intent of what? Of divorce. That is to deal with what? Collusion. And we have the case of Chawad versus Chawad. The case of Chawad versus Chawad, we realize that court denied the petitioner divorce on grounds that the evidence was what? Was formulated with the intention of asking for a divorce. And realizing the case of Chawad versus Chawad, court stated that it is never the fact that collusion has two elements, or it is categorized into two, whereby the parties can also put up evidence which is true but has been corruptly preconnoted to divorce. It is true, but the truthfulness of the intention was to get divorce. And also where the parties or the party forms facts to form the basis of the judgment of what? Of a divorce. That is to deal with what? Collusion. Then we have what they call condonation. You get? Condonation, basically it is like, condonation is you forego, you forget and move on. You get? When you read Section 9 of the Divorce Act, condonation basically it means that you forget something and you move on. You forgive and reinstate. You get? For example, there is a case of Mugonya versus Mugonya. In this case of Mugonya versus Mugonya, realize that the state of forgiveness and reinstatement to the former marital status where both parties forget the past and reconcile. That was in the case of Mugonya versus Mugonya. You forget the past and reconcile. Once you do such, which means that in the near future you cannot ask for what? For divorce, because you forgot and reconciled. You get? Then we also have the case of Cramp versus Cramp, still under condonation. Condonation basically here, where basically they say that sometimes mere forgiveness does not amount to what? Condonation. But forgiveness must be corroborated with what? With actions. You get? You can't just say that I've forgiven you, but your actions don't imply the forgiveness which you told the what? Your spouse. So mere forgiveness cannot amount to what? Condonation. The forgiveness must be corroborated with what? With the actions. You get? Must be, for example, the actions that I'm trying: cohabitation, conjugal rights, restoring through the mutual relationship, like that, for example. Yeah, that was in the case of Cramp versus Cramp. And basically that's what I can talk about condonation. Then we have what they call connivance. Connivance, this is the forgiveness with corruption on one of the parties. That is connivance. It's like forgiveness with corruption on one of the what? Of the parties. You get? Connivance is like, in the layman's understanding, is like you have also involved, you understand, in the action. There is your upper hand, you are a party to the action that, or to the ground that we are asking divorce for. You are a party too. So basically that is to deal with what? Connivance. I'll give the good case of Godfrey versus Godfrey and Well. The case of Godfrey versus Godfrey and Well, realize that here the wife told the husband that I have my friend whose wall wanted to come over. You get? The husband didn't hesitate. Told the wife, it is okay. You let the wall come together. Then it was a day whereby the husband came back well drunk. He found Wall and the wife in the sitting room talking to each other, embarrassing each other in that manner. So the husband told them that, lamented that, if you two want to go to bed together, then why the hell don't you? You understand? If two of you want to go to bed together, then why the hell don't you? It was like giving them a green light that go to bed. If you want to, you go to bed. Then the wife followed the husband, his wife. They went to bed together. They had some good moment. Then in the morning, the husband was like, you have cheated on me. Let me file what? A divorce. I want a divorce. You get? But however, court held that the husband's act was an act of connivance. You understand? The words that lamented were prima facie, they showed connivance. So the court held that it cannot grant what? It cannot grant divorce to that what? On such ground. So that's to deal with bars to divorce. Those are absolute bars to divorce. But however, we also have discretionary bars to divorce that are provided under Section 8, subsection 2 of the Divorce Act. We have the discretionary what? The discretionary bars to divorce. Under the discretionary bars to divorce, first of it, we have unreasonable delay. You get? We have unreasonable delay. Unreasonable delay means that you have cohabited or you have spent a person a couple of times together, then afterwards you are filing in a divorce. Take for instance, if I committed adultery and I'm the husband and the wife gets to know, but the wife takes a long period of time minus petitioning to court. Then afterwards, when it goes like for a period of 5 years, court basically may hesitate awarding what? Divorce, due to the fact that there was unreasonable delay. And this is portrayed under the case of Johnson versus Johnson. The case of Johnson versus Johnson, court held that the fact that the respondent, his wife, had become insane and had been in an asylum for years, and that the husband had been expecting to release by her death, but was held to be sufficient answer to a plea of unreasonable delay. In this case, the wife just simply refused to die. Actually, the wife had gone insane, but the husband thought that maybe he will get relief once the wife dies. But however, the wife didn't die. You get? So he spent time with her together. Then afterwards, he went to court. But however, court held that there was unreasonable what? Delay to petition in the file. So, and there is also a good case of Benny versus Benny. In this case of Benny versus Benny, the husband had taken no particular steps for the divorce of his wife until an interval of 20 years had passed. You get? The wife was living with another man. You get? The husband knew it but didn't petition. So as a result, when he also saw someone that was good for him, he said, let me divorce my wife on the grounds of adultery. But court held that there was unreasonable what? Unreasonable delay to the fact. That is Benin versus Benin. Then another bar under discretionary bars, we have petitioner's own adultery under Section 10 of the Divorce Act. It is like, I'm the husband, I can commit adultery out there. Then afterwards, knowing that my wife has got to know that I committed adultery, then in the morning I go to court filing for what? For divorce, just because I committed what? Adultery. So that is the petitioner's own adultery. You get? You commit adultery, then you petition for divorce. Until you are the same person that committed what? Adultery. In that instance, court cannot tolerate what? Such nonsense. So basically, the person that is the victim in your act is the one that can petition for divorce in that manner. Then there is a case of Blunt versus Blunt. And in the case of Blunt versus Blunt, court laid down considerations that will be taken in accounting or in accounting its exercisation in its discretion when a petitioner is guilty of what? Of adultery. That is the case of Blunt. It laid Blunt versus Blunt. It laid down consideration. And one of the consideration is the position and the interest of children in the marriage. The position and the interest of any children of the what? The marriage. The question whether if the marriage is not dissolved, there is a perspective of reconciliation. Those are the questions that are put forward by court. Remember, these are discretionary bars, and you know the meaning of discretionary. It is upon the court is what? Wanting to do something. Then the interest of the petitioner, and in particular the interest of that the petitioner should be able to remarry and live respectively. The interest of the party with whom the petitioner has been guilty of misconduct with special regard to the prospects of the future what? Marriage. The interest of the community at large to be judged by the maintaining a balance between the scarcity of marriage and maintenance of the union. So basically, those are the grounds that were laid down in the case of Blunt versus Blunt. Then, still under, we have discretionary bar of conducing conduct. Any conduct which conduces the commission of a marital offense, it is taken as a discretionary bar to divorce. And in the case we have Lander versus Lander. Lander versus Lander, under this case, the decision, the wife refused to agree to the intercourse until the husband filed for divorce, and it was held that the wife was guilty of conducing what? Conduct. Because you are the very person that has conduced the conduct. You get? You have refused to give me sex, which means you have conduced me to ask for what? For divorce. It is like you are forcing me. So that is the conducing what? Conduct. Those are some of the bars to divorce, both absolute and discretionary what? Bars to divorce. Then we also have orders obtained or granted out of what? Of divorce. But these orders, I'm going to make them in another discussion. Thank you for listening. Subscribe and stay tuned. Thank you very much.